Let's pay attention and listen to this very important immigration news. Over the couple of weeks, immigration news across YouTube and social media has been filled with alarming headlines about a so-called new visa ban, sudden travel blocks, and claims that green card holders may no longer be safe to travel in 2026. Some videos suggest immigration has been frozen. Others say visas are being canceled overnight. And for many families, this flood of information has created confusion, fear, and uncertainty about what is actually happening. That is exactly why this video is necessary. When immigration policy shifts, misinformation spreads quickly, and not all headlines reflect the full or accurate picture. So instead of speculation or panic, what matters right now is clarity. In this video, let's separate facts from rumors, explain what the Trump administration has actually ordered regarding visa bans and travel rules in 2026, clarify how these policies affect green card holders and visa holders, and help you understand what is correct information and what is not before making any decisions. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. To understand the current situation, we need to start with the expanded travel ban that took effect on January 1st, 2026. In December 2025, the administration issued a presidential proclamation that builds on prior travel restrictions by expanding the list of countries whose nationals face restrictions on entry and visa issuance. This new ban was designed to restrict travel from several dozen countries based on national security and public safety criteria. Under this expanded ban, foreign nationals from designated countries who are outside the United States on January 1st, 2026, and do not hold a valid U.S. visa on that date are subject to restrictions on entry and, in some cases, on visa issuance. It's important to emphasize that existing visas are not automatically revoked. If a traveler holds a valid visa issued before the ban's effective date and meets all other entry requirements, they can generally still use that visa to enter the United States. A key point to understand: the ban does not apply to individuals already inside the United States. Lawful permanent residents, commonly known as green card holders, are not stripped of their status simply because of the travel ban. Green card status remains valid, and holders generally retain the right to re-enter the U.S. if they maintain proper documentation and comply with all immigration rules. The expanded ban covers both immigrant and non-immigrant visas for nationals of certain countries. In practice, this has meant that individuals from designated nations who are planning to come to the U.S. to live, work, study, or visit must now meet much stricter eligibility criteria, apply at U.S. embassies or consulates equipped to handle the restrictions, and navigate enhanced security reviews. Almost simultaneously, the U.S. State Department issued a separate order on January 14, 2026, to pause immigrant visa issuance for citizens of 75 countries. This action, part of an ongoing evaluation of screening procedures and public charge grounds, means that consular posts worldwide have been instructed to halt the issuance of new immigrant visas to nationals of those countries until further notice. Under this directive, individuals from these 75 countries appear to still be able to submit visa applications and attend interview appointments, but consular officers are instructed not to issue immigrant visas while the pause is in place. This affects both family and employment-based visa applicants who are outside the United States. To be clear, this visa pause applies only to immigrant visas, meaning green card applications processed through U.S. embassies abroad. It does not apply to non-immigrant visas such as tourist B1B2, student FM, or certain work visas like H1B, which continue to be processed based on standard procedures unless otherwise restricted by separate rules. This means that while immigrant visa processing is restricted for these 75 countries, temporary visitors and workers from those same countries may still receive visas and travel to the U.S. under appropriate categories, provided they are eligible and meet other requirements. There is broad overlap between the expanded travel ban list and the countries affected by the immigrant visa suspension, but they are not identical. The expanded travel ban includes restrictions based on national security assessments and applies to visa issuance or admission for designated countries, while the immigrant visa suspension focuses on a broader set of 75 countries identified by the State Department for a pause in visa issuance pending policy review. Now let's talk about what this means for green card holders and existing visa holders. As noted, green card holders who already have valid permanent residency are broadly exempt from the entry restrictions of the expanded travel ban, meaning they can still travel to the United States and re-enter, as long as they carry valid documentation and satisfy standard entry requirements. Exceptions are rare, and typically require specific legal issues unrelated to the travel ban itself. Similarly, individuals who already hold valid visas, whether immigrant or non-immigrant, generally retain the right to enter the U.S. on that visa. The travel ban does not automatically invalidate existing visa stamps. However, those visas may still be subject to individual refusal at the port of entry if border officials determine the traveler does not meet admissibility criteria, just as they would under normal immigration law. For visa applicants currently outside the United States, the new restrictions present real challenges. If you are from one of the designated countries and you do not hold a valid visa as of January 1st, 2026, you may face enhanced screening and possible denial of visa issuance until policy exceptions or waivers are clarified. Similarly, if you are from one of the 75 countries subject to immigrant visa suspension, your case may not move forward to issuance until the temporary pause is lifted. For families and workers waiting on immigrant visa processing, this means planning cautiously. If your priority is to reunite with family or begin work based on a newly approved immigrant petition, you should remain in close contact with your attorney and monitor embassy and State Department guidance. Keep your documents updated and be prepared to demonstrate strong financial, background, and admissibility information whenever interviews are rescheduled or policy updates are issued. Another layer of complexity is the administration's use of the public charge ground of inadmissibility, which has been invoked in recent policy guidance and has influenced decisions about who may be deemed eligible for visa issuance. While public charge decisions have long been part of U.S. immigration law, the current policy environment places added emphasis on financial self-sufficiency and long-term independence from public benefits when evaluating visa applications from certain countries. Public charge considerations do not apply to green card holders returning to the U.S., but they may affect visa applicants abroad if consular officers determine that a candidate is likely to require public support after admission. This can further complicate immigrant visa issuance in the current policy climate. Some experts have also pointed to advocacy that these pauses and bans will lead to long-term declines in legal immigration numbers, potentially reducing overall immigrant admissions by a significant percentage over the next few years, depending on how long the restrictions remain in place. At the same time, it's important to balance this with realistic context. Travel bans and visa suspensions do not eliminate pathways for immigration. They restrict and add layers of review. Lawful permanent residents continue to live and re-enter the U.S. under their status. Many non-immigrant visas continue to be issued when eligibility is demonstrated. And temporary policy measures can be modified or rescinded over time based on legal challenges, administrative revisions, or new executive actions. If you're a green card holder or a current visa holder, the most important thing right now is to stay informed, maintain your documentation, and consult a qualified immigration attorney if your case involves complex eligibility issues such as public charge concerns, prior immigration violations, or long absences from the United States. What we are seeing in January 2026 is a period of expanded travel restrictions and temporary visa suspensions designed to increase screening and vetting, especially for immigrant visas, and not a blanket ban on all lawful immigration. The details matter, and understanding how existing rules interact with new proclamations is essential for anyone navigating U.S. immigration this year. We will continue to track official announcements and policy changes and explain what they mean for green card holders, visa applicants, and families around the world. That's all we have for this bulletin. The U.S. Immigration News Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you haven't already, please subscribe to the U.S. Immigration News Channel. Thank you for watching, and we'll see you in the next video.